She's starting live.
Okay. You're recording? All right. Well, then I guess we'll call this meeting to order. Good afternoon. I am Shane True, Chairman of the Environmental Quality Council. This meeting is being held in Torrington, Wyoming, in the boardroom on the campus of Eastern Wyoming College, and also virtually via video conference. It is 1 p.m. on September 17th, 2025. Present today our council members, Bill Stafford, Stan Blake, Marjorie Bedessum, and myself, Shane True, and JD Radakovich and Ryan Green are attending via video conference. Also present are council staff Kelly Duran and Joe Gerardin, as well as EQC legal counsel Ryan Shellhouse. First on the agenda is a rulemaking package from the Water Quality Division. I'll turn things over to Bill Stafford, who's the hearing officer for this case.
Thank you, Chairman. We're going on record first. We are going on the record in docket number 25-33102, rulemaking hearing on proposed revisions to Water Quality Rules, Chapter 28. I'm William Stafford, and I'm acting as a hearing officer in this matter. Today is September 17th, 2025. Time is 1:03 p.m. Present today are council members Shane True, Stan Blake, Marjorie Bedessum. Joining us remotely are Ryan Green and JD Radakovich. Also present are council staff Kelly Duran, Joe Gerardin, and legal counsel Ryan Shellhouse. This is a proposed rulemaking package revising the Water Quality Rules, Chapter 28, Standards for Issuing Permits for Commercial Oil Field Waste Disposal Facilities. I understand the department would like to make a presentation. Please state your names for the records and proceed when you are ready. Thank you.
Thank you. Good afternoon, Mr. Chair, Mr. Hearing Officer, members of the council. My name is Jennifer Zigmut. I am the administrator of the Water Quality Division for Wyoming DEQ. With me today, I have Keenan Hendon, who is our Water and Wastewater Section Manager. Also Gina Thompson, who is our Policy and Planning Analyst. And then online with us today from the Attorney General's Office, we have Patrick Kent and JC Rudloff. So we're pleased to be here today to present proposed revisions to Chapter 28, Standards for Issuing Permits for Commercial Oilfield Wastewater Disposal Facilities, also known as COWDIFs. In summary, a COWDIF is a facility that receives or has received for disposal produced water, exploration and production waste, or other wastes approved by DEQ from persons other than the owners and operators of the facility. So the key part of that definition is that it's a commercial operation. The Oil and Gas Conservation has authority to permit non-commercial pits. DEQ permits the commercial pits, but we do work closely with oil and gas on permitting these facilities throughout the state. This is a state program. It's authorized under the Wyoming Environmental Quality Act, specifically statutes 3511, 301, 302, and 306. It is not a delegated federal program under the Clean Water Act or Safe Drinking Water Act. So just making sure the council is aware that this is not a rule with EPA oversight. We currently have 33 active COWDIFs in the state that are permitted by DEQ. The purpose of our permits is to make sure that the facilities are designed and operated in such a way that we're protecting human health and the environment. Protection of groundwater is one of our most important considerations. So in Chapter 28, this is the rule where we establish the design standards that these pits have to meet in order to protect public health and the environment. A sister chapter, Chapter 14, is where we've established financial assurance requirements for these pits. And so both of those chapters come into play when we're permitting a COWDIF. It hasn't been that long since the council promulgated Chapter 28. It's a relatively new rule. It was first promulgated in 2020. So at that time, we had pretty extensive Attorney General feedback. We've gone through the readability, the reorganization, the incorporation by reference that you're seeing us present to you and other rules recently. So the revisions that we are proposing are pretty specific. They're not extensive. And there are really just three main areas where we saw the need for improvement. The first area, and this is really the driver for the rule, is that we wanted to update some public notice requirements. When the rule was originally issued, it was written in such a way that it required public notice for any permit action. So all permit modifications, all new permits, and permit transfers. It's not uncommon for these pits to be transferred between operators. So we were required to go out to public notice whenever we received a transfer request. That's not consistent with other water quality programs. Typically, we only require public notice if it's a new permit or a significant modification, or in some cases, a termination of a permit. So what we wanted to do was to make that public notice requirement more consistent with our other programs. Only require it for a new permit, a substantial modification, but to not have to do public notice anymore for minor modifications and these permit transfers. We have done these notices for 5 years, and during that time, we have not received any public comments on the transfers. So I think this is a good streamlining step without sacrificing transparency and without reducing environmental protection. So if we were going to open the rule, it was also an opportunity to make some improvements in a couple other areas. And this was done with feedback from Dennis Lamb, who some of you may know. He was with the DEQ for over 30 years. He was our CAUTIF program lead, and he was able to inform some of these edits before he retired last year. So we were grateful for his input. He really worked closely with the operators and had a good sense of where we could also make some improvements to this rule. So the two additional areas where we have made some changes would be to specify leak detection standards and the actions that an operator needs to take if we detect leaks at certain rates. And then secondly, to clarify freeboard design requirements to make it clear what an applicant needs to provide to us to show that they have sufficient freeboard to protect the environment. So those are the three main areas where we've made changes. We've made some additional global changes to ensure consistency with other rules, not spelling out numbers, for example, only stating water quality rules rather than rules and regulations, those kinds of changes. And then in terms of process, as usually we started with scoping. During that formal scoping period, we only received one comment. It wasn't related to CAUTIS, but we directed that person to where they could find more information on the subject they were interested in. Prior to the advisory board meeting in March, during that public comment period, we received one comment letter from an NGO. That comment letter and our responses are included in the rulemaking materials. And those comments did prompt some further revisions to the rule that we presented to the WAB in March. And so during that meeting with the WAB, there was good discussion about the rule. We clarified the unit of measurement used for leakage rates, gallons per acre day. But the only revision we made in response to the WAB conversation was to correct a typographical error. They did not have any other directives for edits. And then finally, prior to this EQC hearing, we did not receive any public comments during the public comment period. We have notified industry throughout this rulemaking process, including our current permittees, and have not received comments from them, but I know, again, they were in close communication with Dennis and now his successor on CAUTIF permitting. So again, we believe these proposed changes provide some good clarification to support regulatory certainty without being burdensome, and we've looked for opportunities where we can streamline, again, without sacrificing transparency and environmental protection. That concludes my overview. Before I wrap up my remarks, I would like to note one error that we caught while preparing for this hearing. And this has to do with section 10D, Romanet IV, capital letter E, III, lines 603 through 607 in the clean version that we originally provided on the EQC docket. This is the section where we are proposing revisions to the leak detection rates. And I'll explain the comment here, or the revisions. And one of those edits in that subsection was presented to the advisory board at the March meeting in response to public comment, but we inadvertently omitted some of the corrected language in the draft that was presented to the EQC. So yesterday, we added 3 documents to the docket: a revised clean version, a revised strike and underline version, and a comparison showing the discrepancy. So the document that I would point you to in order to explain the change is if you turn to that comparison document, and it's titled Proposed Correction to Chapter 28. It's just a one-pager. Kelly, do they have access to that? Okay. Thank you. Okay. So if you open that document, you can see the language in the current draft versus the proposed correction. And the language in green is what was not included in the draft presented to the EQC, but we intended to include in the draft. And I'll give you a minute, make sure everybody has a chance to open up that document. And Mr. Hearing Officer, I can read that into the record if you'd like me to, the change. Okay, so in the current draft in a subsection III, it read, leakage rates that exceed 500 gallons per acre day shall require the operator to complete all requirements of section 10D, Romanet 4, capital EI, notify the administrator of the leak in writing within 5 business days, cease discharge to the identified leaking ponds, and implement all necessary corrective action measures to mitigate the liner leakage. The correction that we had intended to include is the language added in green. So it reads much the same. Leakage rates that exceed that 500 gallons per acre day shall require the operator to complete all requirements of section 10D, Romanet 4 EI, notify the administrator of the leak in writing within 5 business days, and cease discharge into the identified leaking ponds until the operator submits confirmation to the administrator that all necessary corrective action measures to mitigate the liner leakage have been implemented and the operator has received written authorization from the administrator to resume discharges. So this language was added just to clarify the process so that if a company had a leak greater than 500 gallons per acre day, they'd be required to cease discharging. This language clarifies the path to start discharging again. We think that was inherent in the original language. So I do feel that the correction here is non-substantive and it just clarifies the intent that once you fix the leak, we'll approve it, get you going again with authorizing discharge into the pond. So again, because we feel this is a clarification and a non-substantive edit, we would suggest that if the EQC proposes to move to approve the rule, that the council considers including those edits with the approved rule. However, if it's your directive that we need to go back out to public notice with that corrected draft, we would certainly do that. But again, we do feel like this is a clarification, just again, making that step crystal clear to the regulated community about what's going to occur and how that process will happen. And with that, Mr. Hearing Officer, that concludes my remarks. We would be happy to take any questions. Keenan is prepared to provide more details about the changes we've made, or of course, we're happy to do a walkthrough of the rule if you would like us to do so.
Okay. Thank you very much, Hearing Officer. I have a couple of just quick questions and then a couple of minor non-substantive suggested edits. On line 104, oh, and I apologize, I'm looking at the strike and underline copy, okay? So on line 104, it says, a theoretical evaluation of the design demonstrates a reasonable probability. In order for that to read correctly and match the ones above it, I would suggest to say a theoretical evaluation of the design that demonstrates. So the word that would make it seem like grammatically. We're okay with that?
Mr. Hearing Officer, yeah, we'd be just fine with that change.
Okay,
Thank you.
Thank you. A lot of the changes in citations to other sections of like chapter 3. Is that because chapter 3 was thus changed?
Mr. Chair, Marjorie, yes, oh, I'm sorry. My name is Keenan Hendon, Water Wastewater Section Manager for DEQ. And essentially, yes, the references to chapter 3 required an update because chapter 3 was recently updated as well.
Okay, perfect. So there really isn't any change in requirement. It's just a change in reference because chapter 3 was edited.
That is correct.
Okay.
It's an alignment with regards to the appropriate references as they were changed in chapter 3 to align with chapter 28.
Okay, thank you. Then I have a question or a potential suggestion for your consideration on line 406 in strike and underline. So when I first read the sentence, I had difficulty understanding it because I think I wasn't pausing in the right spot because it says demonstrate with calculations compensation for wave action. So is it possible to say demonstrate with calculations the compensation for wave action? Just to make, because it's just odd, calculations and compensation right after each other.
Mr. Hearing Officer, yeah, we'd be just fine with that edit as well.
Okay,
Yeah.
I think it might just help to clarify.
Sure.
I
Thank you.
might be the only one who doesn't understand, but you never know. There may be somebody else. And then there was only one other minor one, and that was on line 800, where it says 30 days public notice, but there's an apostrophe after 30 days, and I don't know that that grammatically needs to be there. It's on strike and underline line 800. It says 30 days, and then there's an apostrophe, like the 30 days is possessing the public notice. It's the very end of line 800.
Mr. Hearing Officer, Councilmember Bedessim, yeah, I think we'd be fine removing that apostrophe. I'm not sure the possessive form is needed
Okay.
there. Yeah,
Thank you.
thank you.
Those are all the minor things, and I just had a general question for me to help understand when I was reading the rule. The section 5, when it says facilities and systems not specifically covered by these standards, what falls in this category when it says not covered by these standards? Because that's the title of the section, and B says the same thing, not specifically covered by these standards. So I just wanted you to explain to me what that means and what falls in that category.
Absolutely, Mr. Hearing Officer, Councilmember Bedessim. So this is language that we typically include in the chapters relating to Keenan's shop, the permits to construct for facilities capable of causing or contributing to pollution. And what it anticipates is that there will be some facilities that use innovative technology that we've not yet contemplated here or is not, I would say, approved engineering standards or methods yet, but for which somebody could make a case that they can demonstrate those methods would be protective, and we might allow it on a pilot basis to try something innovative. So I'll let Mr. Hendon chime in here if I've missed anything, but that is the intent, is just to allow for something we haven't anticipated so that we wouldn't have to do rulemaking modification if a company came in with an innovative idea that we agreed would be protective.
Okay, gotcha. Thank you. That was a perfect explanation.
Yes, I concur with Ms. Zygmunt, but essentially it provides an off-ramp should some new technology arise that can perform the same material applications that's identified within our Chapter 28.
Mm-hmm. And so this gives you some flexibility and makes you cover everything that you might not yet know about. Okay, thank you very much. That's all I have.
Councilman Blake, do you have any questions? No. Councilman Green?
I do not. Thank you.
Okay. That's all.
I didn't hear you before.
Oh. Councilman Rudakovich?
No, I don't have any questions. Thank you.
Okay. Thank you for your presentation. We appreciate it. Is there anyone from the public who wishes to comment in support of the proposed changes? Is there anyone from the public who wishes to comment in opposition to the proposed changes? Is there anyone in the public who wishes to make a neutral comment or any other comment of the proposed changes? Seeing none, thank you all for your input on this proposed rulemaking. And I'll close the hearing and turn the gavel back over to Presiding Officer Chairman True. Thank you.
Thank you, Councilmember Stafford. Thank everyone who spoke today and asked questions, gave comments, or provided information. The council appreciates all of your input and the time attending this meeting to bring your comments forward. We're also thankful for the time the department spent preparing information for the council to review as we consider these proposed changes and for public comments submitted as part of the rulemaking process. Thank you, Administrator Zigbut and your team. I will now ask for a motion to approve the revisions to the Wyoming Department of Environmental Quality, Water Quality Rules, Chapter 28, as proposed by the department.
So moved.
Second. It's been moved. Yes.
Orange has changes also Hooper.
Yes. Was that part of your
Yes,
motion, Mr. Stafford, to
yes.
include not only the changes from Mars, but also from
That's what the administrator proposed.
yes, and the administrator. Yes.
And Mr. I would just want to make it clear that the motion includes your 3 tweaks and then the clarification that was just filed yesterday. And so as long as that was included in the motion, I'm good with that.
Yes. And you concur with your second?
I am very cool with that second,
Great.
as amended.
It's been moved and seconded that we approve the proposed revisions. Does anyone have any discussion? Okay, so now we will move to a roll call vote on the motion to approve the proposed revisions to the Water Quality Rules, Chapter 28, including Councilmember Bedessam's changes and the changes submitted by the department yesterday. We'll start Councilmember Blake.
I vote aye.
Councilmember Bedessam.
Aye.
Councilmember Green.
I vote aye.
Councilmember Stafford.
Aye.
Councilmember Radakovich.
I vote aye.
And I vote aye as well. So the ayes have it and the motion is carried. The statement of principal reasons for adoption will be forwarded to the hearing officer for signature. So we got through the first one. Next on the agenda is a rulemaking package from the Land Quality Division. So I will now turn the gavel over to the hearing officer on this case, Mr. Blake.
Thank you, Chairman True. We're going on the record in docket number 25-4101, the rulemaking hearing on proposed revisions to Land Quality Division Coal Chapter 12. I am Stan Blake and I am acting as the hearing officer in this matter. Today is September 17th, 2025. The time is 1:24 p.m. Present today are council members Shane True, Marjorie Bedessam, William Stafford, Ryan Green, and J.D. Radakovich via video conference. Also present are council staff Kelly Duran, Joe Girardin, and EQC legal counsel Ryan Shellhouse. This is a proposed rulemaking package, revising LQD Coal Chapter 12, procedures applicable to surface coal mining operations. I understand the department would like to make a presentation. Please state your names for the record and proceed when you are ready.
Thank you, Mr. Hearing Officer and Council. My name is Brandy O'Brien. I am the Land Quality Administrator, and with me today I have Craig Holtz, also with the Land Quality Division. And today Craig will just be covering for you our proposed changes for Chapter 12, procedures applicable to surface coal mining operations.
Thank you, Administrator O'Brien, council members, and Chairman True, and Hearing Officer Blake. Thank you for taking the time to hear the rules from the LQD division. I am Craig Holtz. I'm with the Land Quality Division. I've been involved in the rulemaking process for LQD since 2005. We also have in attendance Gregory Weiss, our LQD Attorney General representative. And I appreciate that because I do get in over my head. Today I'll be presenting the proposed revisions to Coal Chapter 12. This is procedures applicable to surface coal mining operations. Chapter 12 was last revised on August 27th, 2014. And I'd like to give a brief background introduction to the revised chapter, followed by a description of the specific rule changes contained in Chapter 12, if that's acceptable to the council. The rule changes for the coal program are typically initiated through 3 different processes. Legislative changes at the state level, at the request of our federal oversight agency, the Office of Surface Mining and Reclamation. And this helps us maintain our primacy over the coal program. And then finally, a state initiative to codify a specific policy. The rules that we'll be presenting today are the state initiative type, so there was no legislation involved, and the Office of Surface Mining has not asked us to make this change. The draft rule revisions originated during discussions with the LQD coal work group and are example of the good work that these industry-specific groups provide to the LQD. The proposed revisions are intended to recognize a specific type of reclamation bond estimate adjustment that would not be considered a formal bond release request. Reclamation estimates are calculated annually under the Wyoming Coal Program, and the LQD believes these proposed revisions will encourage more contemporaneous reclamation due to a decrease in the annual bond estimates, while also still recognizing the actual costs of reclamation. The proposed revisions also provide clarity by specifically codifying an LQD policy. The corresponding Office of Surface Mining regulations at 30 CFR 800.15, and that's the adjustment of bond amounts, states that a permittee may request a reduction of the amount of the performance bond upon submission of evidence to the regulatory authority proving that a permittee's method of operation or other circumstances, and that's what we lean on here, reduces the estimated cost of the regulatory authority to reclaim the bonded area. And that's in instances of forfeiture, et cetera, where the state has to do the reclamation. The LQD is proposing to allow for a bond reduction request based on a decrease in the volume of material required to reclaim the final pit, final cut or void created at the surface mining operation. So as you are well aware, these pit voids are massive. To fill in half of it is a big undertaking. So what we would be doing is crediting from that work. That's also work that the LQD or the state would not be required to do. And using that moving forward in the bond calculations. The LQD did submit this as a informal amendment to the Office of Surface Mining on March 1st, 2024 for review before we proceeded to the environmental quality or to the Land Quality Advisory Board. OSM found that the proposed changes to be as stringent as SMACRA and as effective as the corresponding federal regulations. So those would be our review under a formal amendment as well. And that was stated in their August 28th, 2024 review letter. And the OSM also suggested a couple of edits, which are contained in today's rules, and were also presented to the advisory board. The LQD received one comment on the proposed rules from Thunder Basin Coal Company LLC in support of the rule changes. And they submitted that comment at the advisory board stage and also at this hearing today. And that was forwarded to you. The comment also suggested an additional edit that was adopted during the advisory board meeting. And with that, I'd be happy to walk you through any specific rule changes to Chapter 12, working from a statement of principal reasons, or answer any specific questions you may have.
Thank you, Mr. Holtz. Does anybody wish him to go through all those, or do we have any questions from the council?
I have one, just a vague question. What's the difference between method of operation and operational parameters? So what are operational parameters?
Absolutely. Take a stab at that.
Yeah, I just added in there. I was just curious as to.
So the methods of operation, Councilmember Bedessum, that would be a more general term, surface mining versus, the drag lines, those types of things.
Mhm.
Whereas the operational parameters are the day-to-day operations.
So more specific.
Yeah.
Okay.
Yep. And each of those, again, depending on the detail, if they were able to submit that as part of the reclamation bond estimate. So if they're, for example, moving their fueling station a bit closer to the pit, there's an operational parameter.
Okay, thank you.
Certainly.
Any other questions from the council? Councilmember Green, any questions?
I do not. Thank you, Mr. Blank.
Councilmember Radakovich, do you have any questions, sir?
No questions at this time. Thank you.
No questions. Any other questions? Thank you for your presentation. I'll now open it up. Oh, I already did that. Never mind. Is there anyone from the public who wishes to comment in support of the proposed changes? Seeing none, is there anyone from the public who wishes to comment in opposition to the proposed changes? Or any of these? Joe, do we have anybody online? Okay, thank you. Is there anyone from the public who wishes to make a neutral comment or any other comment of the proposed changes? Seeing none, thank you all for your input in the proposed rulemaking. I will now close the hearing, turn the gavel back over to the presiding officer, Chairman True.
Thank you, Mr. Blake. I want to thank everyone who spoke today, asked questions, gave comments, or provided information. The council appreciates everyone's input and the time spent attending this meeting to bring your comments forward. We're also thankful for the time the department spent preparing information for the council to review as we consider these proposed changes and for the public comments submitted as part of the rulemaking process. So thank you, Administrator O'Brien and your team. Now I will ask for a motion to approve the revisions to the Wyoming Department of Environmental Quality, Land Quality Division, Coal, Chapter 12, as proposed by the department.
So moved.
I'll second. Second, okay. It has been moved and seconded that we approve the proposed revisions. Is there any discussion from the council? Hearing none, we'll move forward for a roll call vote on the motion to approve the proposed revisions to LQD Coal Chapter 12. Councilmember Blake.
Aye.
Councilmember Bedessum.
Aye.
Councilmember Green.
Aye.
Councilmember Stafford.
Aye.
Councilmember Radakovich.
Aye.
And I vote aye as well. So the ayes have it and the motion is carried. And the statement of principal reasons for adoption will be forwarded to the hearing officer for signature. Kelly, do we have any administrative business? Okay. And anyone have a need for executive session? Just to make sure I go through the whole roll here. Okay. So that concludes all items on today's agenda. Thank you for your attention to these matters. So the best part of the meeting, I need a motion to adjourn.
I would make that motion to adjourn, Mr. Chairman.
And we have a second. All those in favor, please say aye. Aye. Any
Aye.
opposed? And the council's adjourned. Quick and easy.
All right.